What's happening? I'm Ross. I wanted to talk a little bit about the student loan forgiveness plan and where it's at. It's right now tied up in court. The White House has appealed to the Supreme Court. So I've got an article here out of Time. It's called "Here's How the Supreme Court Could Rule on Student Loan Forgiveness." So I want to get an article a little bit. It gives a little bit more of the technicalities of the legal case. So without further ado, let's get into it. Katie Riley. This is out of Time. Katie Riley's from last week, November 22nd. The U.S. Supreme Court is preparing to weigh in on the legal battle over President Biden's student loan forgiveness plan, which is currently blocked by two different rulings. But legal experts say that even if the court sides with the Biden administration, there are still legal hurdles that will delay the relief for borrowers. In a filing on Friday, Solicitor General Elizabeth Prelogar asked the Supreme Court to vacate the nationwide injunction on the debt forgiveness program or set the case for expedited briefing and argument this term to avoid prolonging this uncertainty for millions of affected borrowers. So basically, they're trying to get the Supreme Court to either clear the injunction or hear the whole case this term. Meanwhile, the Education Department began notifying some borrowers that they were approved for student loan forgiveness while acknowledging that they won't actually see any debt relief until these legal challenges are resolved. On Tuesday, Biden announced that the Education Department will extend the pandemic-related pause on the student loan repayment while litigation plays out, aiming to give the Supreme Court an opportunity to hear the case in its current term. Student loan payments will resume 60 days after the debt forgiveness program begins or after the legal challenges are resolved. If there isn't a resolution by June 30th, 2023, student loan repayments will resume 60 days after that. So that would put it at the end of August, July, August. So if there's no resolution, we're looking at late August for repayments to start. So I would assume it'd probably be that September 1 maybe. We're extending the payment pause because it would deeply unfair. It would be deeply unfair to ask borrowers to pay a debt that they wouldn't have to pay were it not for the baseless lawsuits brought by Republican officials. Blah 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 blah. Okay, so they're going political as usual. Legal experts say it's hard to predict how the Supreme Court will rule, given the many complicated questions at play. The court could eventually rule on the legal merits of the student loan forgiveness program. However, right now the court is only deciding whether to allow the Eighth Circuit's injunction blocking the program to continue. For the Biden administration and for actual people who matters, it's whether the current state of affairs remains, says Tara Grove, University of Texas school law professor who focuses on the federal judiciary and the separation of powers. Grove thinks it's possible the Supreme Court will allow the appeals process to play out with the injunction in place. But she thinks that it's just as likely the court could determine the plaintiff's lack of standing, meaning that they would be immediately harmed by the policy, and reversed the block on the student loan forgiveness. So basically, she's saying they can go either way. I mean, obviously, we knew that beforehand. They can go either way. So it's not much insight right there. At least so far, the Supreme Court has shown an unwillingness to get involved in lower court proceedings around the preliminary injunction type of issues, said Thomas Bennett, an associate professor of law at University of Missouri who studies federal courts. And he notes that reversing this injunction alone won't allow the debt relief program to resume because the program was also blocked by a federal judge in Texas in a separate case. The Justice Department is appealing that ruling. It's unlikely the Supreme Court will sort out these preliminary issues until it has all of those cases before it, said Bennett. Yeah, so it's unlikely they're going to do anything until they get that case, this case. I don't know if there's going to be any other challenges somewhere, but they're not going to do anything until they get all the cases together. So, and I don't think that's going to be this term. I don't know. I could be mistaken. I don't know how quickly the cases move, but I think the term is over in June 30th when they set the deadline for the pause. So if it doesn't get heard by then you're back to paying in, late August, early September, 60 days after June 30th. So again, July's 30 days, and then August, all of August is 31 days. So it'd be like August 30th or something like that. But okay, but I can see this. If the court doesn't rule on it and it goes past that, I don't think the pause ends. I think they're going to go back and extend the pause for as long as it takes. So the back and forth over the case has focused heavily on whether plaintiffs' 6 Republican-led states who argue they will be harmed by lost tax revenue as a result of debt cancellation have standing to sue the U.S. U.S. District Judge Henry Autry initially dismissed the lawsuit in October, saying the states lacked legal standing because the program's effect upon future taxation is uncertain. But the Eighth Circuit Court of Appeals concluded that Missouri, one of the 6 states, likely has legal standing, saying that Missouri Higher Education Loan Authority, MOHELA, a student loan servicer, will lose revenue because of debt cancellation and may well be an arm of the state of Missouri. And may well be an arm of the state of Missouri. It says it may well be an arm of the state of Missouri. Not that it is an arm of the state of Missouri, or not that it's not an arm of the state of Missouri, but it may well be. Okay, whatever. While the court did not yet rule on the legal arguments in this case, it granted a preliminary injunction noting that the outcome of the case will affect the finance of millions of Americans. It's not clear if the Supreme Court will agree with that reasoning, but some insight into the court's view on the state standing can be found in the 2007 case, Massachusetts v. Environmental Protection Agency. In a 5-4 vote, the Supreme Court decided that Massachusetts had standing to sue the agency, favoring the idea that states deserve special solicitude or special consideration when trying to prove legal standing. But so already they've had one case where a state was able to sue a federal agency, but it states here, but the makeup of the court is different today, and its conservative majority could lead to a different outcome. In the 2007 case, Chief Justice John Roberts dissented, along with conservative justices Antonin Scalia, Clarence Thomas, and Samuel Alito, arguing that Massachusetts should not have had standing to sue because the state had not suffered a concrete injury. The constitutional role of the courts, however, is to decide concrete cases, not to serve as a convenient forum for policy debates, Roberts wrote in his dissent. So I guess they're saying right now that there has been some kind of legal precedence in the past, but that may all go out the window because of the conservative makeup of the court. So they may rule differently than what they've ruled in the past, right? And the conservatives dissented last time, so this time they're in control of the Supreme Court. So they may just stop the whole thing. Who knows? We got to wait and see. Grove says the Eighth Circuit took a narrow approach in addressing the standing question, focusing only on Missouri. If any state were able to sue over a federal program because of its effects on tax revenue, she says, that could open up the floodgates for lawsuits over any number of federal programs. I think what the Eighth Circuit was clearly trying to do was allow a lawsuit that would not open the floodgates to lots of other standing claims, Grove says. It's entirely possible that judges that are kind of skeptical of the executive action or administrative action would strike it down and enjoy it, Michael Santambrogio said, a law professor at Michigan State University who studies administrative law, federal courts, and constitutional law, said in a previous interview. That's a very real risk at the moment. So what he's saying is they could go up to court and get it struck down and get it put out of commission, enjoin it, prohibit it from doing something. So it's not looking good for the it's not looking good for the federal loan forgiveness program. At some point, if they don't get what they want from the loan forgiveness, they're just going to keep extending the pause out. At least until the next election, right? It's always until the next election. So, I don't know. Those are my thoughts. What do you think? We'll see. Tell me what you think in the comments. Hey, if you made it this far, if you got any value out of this video, please give a thumbs up. Maybe even subscribe. It doesn't cost you anything, but it will help me out immensely. Thank you. Peace.